There we
Okay.
go. Perfect.
All right. So I just thought we could get started and look through the language of the proposals for changes and just allow anybody who wants to kind of um, talk about them, express any support or concerns or both, and and then just see if there's enough consensus on any of it that we could present it to the full work group for forwarding it on to the commission. And um, the full task force meets on the 21st, I think. So this will probably be our last opportunity to talk about this particular proposed language before we send it forward. So I don't know if anybody has a burning desire to go first, but whoever wants to pipe up, please do that. All at once. Jim, you're muted. Jim, I'm sorry, you're muted.
Can you hear me now?
I can.
Okay, thank you. In subsection 2, the proposed revision adds the word supersedious. The appellant shall file a supersedious undertaking. The subsection 2 deals with undertakings for costs, and I think we should really work to keep the concept of an undertaking for costs, which must be filed in order to take an appeal, separate from provisions relating to supersedious undertakings, which you only need to file if you want to stay enforcement of the judgment. I recognize that ORS, whatever the statute is that addresses undertakings applicable to circuit court, is not a model of clarity and kind of in places perhaps muddles the two. But I think we have the opportunity here to separate out those two different concepts.
Okay, I'm sorry, Jim. I'm looking at this and I don't see supersedious in subsection 2. Is this for 25 sub 2?
Section 25, subsection 2, correct.
Right. Just a minute.
Are you looking at the draft that Amy sent out?
I'm looking at what you sent out, Anna, the one that you responded to.
Would it be helpful if I shared my screen because I have it up? That might be, we could all be on the
Sure.
same page.
Yeah,
Okay.
there was an update.
Oh, okay.
Share. And now I'm not sure which screen I'm sharing with you guys all, so if you can see all my junk.
Okay, I got it now. Okay, now I see it. Okay. Okay, now I see that. Yeah, okay. Okay.
But Jim, wouldn't anytime that there's a tenant is appealing one of these, wouldn't they, don't you think they would be seeking a stay of the enforcement pending the appeal to the circuit court?
Probably.
So I'm just curious.
We're addressing here all appeals from justice courts in all kinds of in all manner of civil cases, not just FED cases. And one other thing I was thinking of suggesting is that that we include wording to the effect that the undertaking for costs, that the supersedious undertaking can either be part of the undertaking for costs or can be filed as a separate document, because it's possible that an appellant might file those at separate times. That is, they might need to get the notice of appeal filed right away and then need a few more days to get together the money to post the security for a supersedious undertaking.
Is my recollection correct that elsewhere in the bill, we've got that at 5 days after the notice?
Yes.
Well, you have to file the undertaking for costs within 5 days. There's currently no limit on when a supersedious undertaking is filed.
Why would the supersedious filing be different if the person wants to stay enforcement?
Because, for instance, if a defendant is appealing a money judgment for, let's say, $7,000, they might be able to come up with the deposit for the respondent circuit court filing fee, which is the amount of the undertaking for costs, relatively quickly, but it may take them a few more days to come up with security for a supersedious undertaking in a larger amount.
In the justice court, Judge Cross, are there instances where somebody is filing a supersedious undertaking on a money judgment, or do you see these only in landlord tenant?
In the small claims, it's certainly the appellant, if you can only prior to the January 1st, the only thing you could appeal is a judgment against you. But you would have to come with the super. You'd have to post the amount of that judgment as part of the process for the justice court to hold in trust, pending the outcome in the circuit court, with the circuit court then directing us what to do with that money. Or bond. Sometimes if it's a contractor, they'll have a bond. But it is currently part of that process.
And how long does the person have to post that?
Under the old statute, I think it was generally interpreted, certainly I did, as the 10-day period that they have, which I thought was ridiculous, which was one of the reasons why I'm glad and I strongly advocated for us making it 30 days.
Okay.
I think Jim had some good points, so that 10-day interpretation may not have been the best interpretation, but that's part of what we hoped would be addressed in this 2460.
So are you suggesting it should be 30, not 5?
The 30 days was in terms of you're now. It had been 10 days before this. Had been 10 days. You had to file, the notice of the appeal and the service and the fees. The appellant had 10 days to get all that done, which was kind of ridiculous, I thought. Now it's 30 days to do those things, but the question in terms of whether or not there's more than 30 days to do the supersedious part of that is, I thought, part of what we were going to hopefully nail down here.
So I'm going to chime in. I think we did not increase the time. We decreased it to 5.
Right.
Because of if you give 30 days in an FED proceeding, what we've already contemplated is that the actual, trial de novo on the merits in circuit court may be occurring right around then. And so we actually shortened the time to 5 in this draft and in prior discussions, because a longer timeline.
I was specifically asked about small claims, as I understood the question, and I was only talking about small claims in that context. I agree the FED is a different ballgame.
Okay. So here's my question, I guess, that, and maybe this will clear things up, is when we're looking at this language, is there language here that is specific to FEDs that we should be looking at as FED language? And is there language that is that would otherwise deal with small claims appeals?
Yeah, there is, if you look at section 2,
Uh-huh.
that applies to everything.
Okay.
Because that's just the undertaking for costs.
Mm-hmm.
Number 3 is just a money judgment on appeal, which refers to every kind of civil case with a money judgment,
Okay.
not including FEDs. So probably
Okay.
small claims.
All right.
And then 3 is, 3B, which is staying enforcement of a judgment for the recovery of real property. That solely deals with FEDs.
Okay.
And coming back to the use of supersedious, I see Jim's point in section 2. I was the one that inserted that primarily because subsection 6, which deals with the FED supersedious undertakings to stay enforcement, used that term. So I wanted it to be somewhere else in the statute besides suddenly popping up in section 6.
Mm-hmm.
But I agree with Jim that saying the appellant shall file a supersedious undertaking for costs is inaccurate. Because when they're filing an undertaking for costs, that is not an action to stay anything. It's just a prerequisite to appeal. And the word supersedious is about a stay. So I would agree that that should be stricken from number 2.
Okay.
But I think its use in 3 and 3B, which I think we need an A if we're going to have a B. But
fussy.
But I think that using the term supersedious in those is appropriate because it is a supersedious undertaking in those instances because it's referring to when the appellant is trying to stay enforcement, whether it be a money judgment or the judgment of restitution in an FED pursuant to the subsection B.
Okay. And so, so in 3A and B, you think the word supersedious should be there, and in 2, it doesn't have to be there.
That's what I think, yeah.
Okay.
Yes, correct.
Okay.
I think that subsection 2 and 3A should be restructured and combined possibly, because we have this statement about undertaking for costs. And then we have the 5-day time limit, and it is ambiguous as to whether that is applying to any undertaking or just an undertaking for costs. And so I think that ambiguity needs to be clarified.
Okay.
And then also with 3A, I don't understand why it says must also include, because isn't that just what a supersedious undertaking is?
Yeah, I think that language is an artifact of the fact that supersedious was inserted up into subsection 2.
Got it.
And so that's inaccurate. So I think that it would need to be reworded to say something like, I think it would be more accurate to say, in order to stay the enforcement of a money judgment on appeal, the appellant must file a supersedious undertaking that includes a promise to pay the justice court judgment, etc.
Yeah, I like that. I kind of like inserting that modified 3A after the first sentence in subsection 2, and then say something like the appellant shall file any undertaking with the justice court within 5 days, and then make for good cause may extend, or unless we want to have 2 different time limits, but I'm just proposing that as a way to clarify things for now.
And would there be a template form prepared for appellants with regard to that promise to pay?
I don't think that's currently in statute. That's something that could obviously be added.
So I only ask because almost all these people are pro se or in small claims.
Yeah, I would support the directive similar to what we had in House Bill, whatever the House Bill number was, to ask the Judicial Department to make forms for various purposes. And I think a form undertaking would be helpful here too.
Yeah.
I would very much oppose combining 2 and 3A because it would once again muddle the distinction between an undertaking for costs, which must be appealed, which must be filed for every appeal from a civil court case, and a supersedious undertaking, which does not, and only needs to be filed if the appellant wants a stay.
Right.
Also,
Oh, sorry, go ahead.
the other thing is, once again, I'm fine with a time limit for filing the undertaking for cost because that's something that you have to file. But a supersedious undertaking being something that you don't have to file and can require a fairly significant amount of money, particularly for money judgments, I don't think there should be a time limit to stay those. Without a time limit, the tenant or the defendant takes the risk that the plaintiff will execute on the judgment before the supersedious undertaking is filed. And so the defendant has an incentive to file it quickly. But as I said, in many instances, it may take the defendant more than 5 days to put together the cash or security or bond to support a supersedious undertaking.
Right. And I definitely wouldn't restructure this by combining the two concepts of the two undertakings. I would absolutely keep them separate. I do think that the 5-day sentence, it's unclear what, if any, time limit there is on a supersedious undertaking. And I feel like it should be clarified.
So, and I think if I'm hearing Jim right, he's like, well, if they don't file it, they don't file it. And then it's executable. The judgment is executable right away. But or I'm sorry, Jessica, that was you. But so do they need a deadline to file?
I guess if they don't need a deadline, we should probably specify that as well.
But it means that it's enforceable, that it doesn't stay the judgment.
I mean, if we're going to put language like that, I think we also need to put expressly that until a supersedious undertaking is filed, enforcement is not stayed. And the reason I suggest that is because, we don't want anyone to mistake the idea that filing the notice of appeal somehow
stays it.
Yeah, stays it.
Yeah.
And I mean, my only thought on having a deadline to file a supersedious, which I'll just put open for discussion, is, I mean, there's sort of what could happen. So the reality of the timeline here is that if I go and request a writ, saying, well, there's no supersedious yet, so I go and request a writ of execution, and the court issues it, then that's transmitted over to the sheriff, and then the sheriff schedules. And the reality is that process from even requesting the writ to an actual lockout date is several weeks. And I think an issue of where we've gone through that entire process and we're one day before the lockout and all of a sudden this supersedious undertaking pops up is a little bit confusing then as to how am I going to find out about that? Is it going to actually stay the impending lockout and so forth. So that's and same with, for
Got it.
example, like a garnishment that goes out for a money
Right.
judgment. You might have gone, 95% of the way through the enforcement process only to have an 11th hour supersedious, which may be fine. Maybe everyone will decide that's fine. That's my only thinking on sort of a certainty, it would promote certainty at a certain point to know whether there is or is not a supersedious.
Mm-hmm. That makes sense.
Are you thinking of that as a FED specific provision?
I mean, given that that's my area, that's where I tend to focus, but I do think it has some relevance in the money judgment context as well, in terms of, I think the only enforcement we're talking about would be garnishments and the like. And, that's an expenditure of time, preparing all the paperwork, potentially sending it to banks and employers and all of those things. And I'm just envisioning a scenario where someone may have even responded to a writ of garnishment, and it turns out that it happened to be the day following a supersedious undertaking that was filed at the last second that nobody knew about.
Mm-hmm.
So that's the only kind of concern I have about placing no limit whatsoever.
So just using FED as an example, if you are granted a writ of execution, that would happen at the trial, right?
No, you get a judgment of restitution at the trial.
Okay.
Then you actually get a second document, which is called the notice of restitution, which gives the tenant, it's a court-ordered vacate date that is usually about a week after the trial.
Okay.
And only after that expires and the tenant is still there, can you then request the writ, and the remaining process is weeks long.
Got it.
So,
right.
so there's a lag time.
So it sounds like if you consider that lag time, and then you go in to get a writ of execution, and you take that to the court, that would likely be, would it be like a week after you got the notice to vacate?
Yes.
Okay.
It's very rare that the notice of restitution is going to be, any quicker than about a week later, because again, we request it from the court. It takes a day or two for the court to issue it, and
right.
Statutorily there has to be at least 4 days after service for that vacate date. So it's about a week.
Okay. All right. And then let's say that week passes, and then do you go in like the next day to get a writ of execution? Or is it like within 3 days or something like that?
I mean, sometimes it's the very next day. It
right.
kind of depends on the specific facts and how
right.
much the landlord is incentivized to be waiting at the courthouse doors at 8 a.m. to get the next step done.
That makes sense. So I'm just wondering if you looked at that logistically and you didn't want to have more, more steps before the supersedious undertaking would be filed, it would seem like your writ of execution date is kind of your goal date. Like you don't want to have to go to the sheriff, you don't want to set that whole administrative next steps in place without knowing that you have some assurance if there's a notice of appeal that's been filed. So I'm just wondering if it makes sense to put your supersedious undertaking within 10 days after the writ of or after the judgment of restitution, like you would give 10 days for somebody to come up with that, as opposed to 5 days, because then they would have a little extra time to know if they're going to want to challenge the vacate, and you would have sufficient time not to kind of go in and take, steps 1 through 8 every single time and then have somebody file something on day 24.
Yeah, I think that's fair. And, and it also, because obtaining the writ is one of the more expensive parts of the process.
Yeah.
And if a lockout is canceled due to a supersedious, we don't necessarily get that money back.
Right.
So I think if people are amenable to some sort of deadline, 10 seems reasonable because it kind of balances those interests of giving the appellant a decent amount of time to figure it out and get things together, particularly if there is a court form at some point.
Right.
And then, but prevents getting 99% executed.
Right.
10
And
days seems reasonable.
Okay. Is there a place that we can put that number in this proposal?
I think that we could just add another sentence to 3A and 3B, just stating, the appellant must file a supersedious undertaking within X days of the justice court judgment.
And you had
The
something,
judgment or of the notice of appeal? I assume it's the judgment you want, but
Judgment,
judgment,
yeah.
because the notice of appeal has to be filed how many days after?
in a small claim, it's 30.
What about FED?
I think it's all 30 days.
I think it's 30 days.
Wait a minute, it's 30 days to file an appeal from an FED judgment of restitution?
I mean, theoretically, you can still appeal it without doing any kind of a stay, although from justice court to circuit court, that would be odd, but
Yes,
yeah.
I would think it would be odd, but
I
One
think
thing we should probably also consider, and maybe someone mentioned it, but in subsection 2, the last sentence does give either the justice court or the circuit court the authority to extend the timeline to file, and that kind of cuts against all of the arguments in favor of having a hard cutoff date. So we'd either need to adjust that or just recognize that the court might find good cause anyway and allow a later filing.
okay, is that language already there in that's not new language?
Well, I think that was a major focus of Heather Marek, I believe, was, and a major focus of this project in general, I think, was wanting to give the judge discretion, particularly about that undertaking for costs.
Right, but what about the supersedious undertaking? Like if you have to put your rent payments, your forward-looking rent payments in place, which is what we've been talking about.
Yeah.
Does the current law allow the court to waive that? I don't think it does, but maybe I'm wrong.
No, it doesn't, because if you look at, well, at least proposed new subsection 5, that gives the court the ability to waive, reduce, or limit the undertaking for costs, or to stay enforcement of a money judgment, but
Right.
does not address eviction.
Right.
So it doesn't appear that authority is there.
Okay. And
Can I interrupt for a quick second?
Sure.
I might have misunderstood your question, but the line at the bottom of section 25 sub 2, the justice court or the circuit court for good cause may extend the time to file the undertaking. That is from 2460. Was that your question of whether it was already in section 25? Yeah. Okay.
yeah, and that's the cost one. And so I'm kind of trying to take us like that one. I don't think we're actually, we don't have heartburn about. I think it's more where the rub came was in the undertaking that with clarification for what can be ordered. We talked about, not wanting to order them to have to file a supersedious undertaking for past due rents in an FED, but that for having to deposit future rents in as part of that, I think that's in the proposal that was in proposed in 5A before.
It's in 6A2 now.
Oh,
So
okay.
the may not require an undertaking to include payment of prejudgment rents, attorney fees,
Right.
or other amounts. Yeah.
Right. Okay. And so that's the piece that I think that we were worried about more than the costs, the ability to waive costs of notice of appeal. And so I guess the question comes to, on these additional pages in 5 and 6, are there any, concerns with the proposal there? And if we fixed 2A and 3 so that we were talking about that just basically it would be the time for filing the undertaking after the notice of appeal, right? And if it looked like in an FED case that it made sense to file that after you file your notice of appeal, if you already have 30 days to file a notice of appeal, then adding 10 days to that would be, it seems like that's a long time to come up with the undertaking. I was feeling like it was 5 days and that's like hardly any time at all, but if it's 30 plus 10, that's 40 days.
Well, I mean, I think the awkward thing is that while you can theoretically file a notice of appeal within 30 days, if you are seeking a stay, all of these shorter timelines are going to drive
Right.
the ship. And so you're not
Okay.
really getting 40 days. I mean, it's
Gotcha.
10 days. Like if
Okay.
if you're going to appeal and want to do a stay, then you're going to beat that 30-day notice of appeal deadline because you have to get your supersedious docs filed within 10 days of the judgment.
Okay. I hear you.
I agree that it's kind of goofy to have a 30-day deadline, but it's not incompatible.
Okay. All right.
So the proposal is that a supersedious undertaking must be filed within 10 days of the date of entry of judgment.
If the appellant is seeking a stay of the enforcement of the judgment.
Yeah.
Okay. Then, so the person would file the supersedious undertaking before they're required to file the notice of appeal?
Yes.
To me, that makes no sense whatsoever. It seems to me you have to file the notice of appeal first. That's the critical document. Well, at least it's one critical document. Having heard the discussion, I could see requiring that the supersedious undertaking be filed at the same time as the undertaking for costs. But I don't think you can, it just seems awkward to me that the defendant would file a supersedious undertaking before filing the notice of appeal. I mean, what drives the filing of the notice of appeal in an FED case, as you point out, theoretically, they may have 30 days, but in the meantime, there's the judgment and then there's the notice of restitution that comes out. What would you say about a week to 10 days later? The tenant presumably realizes, well, I need to get my notice of appeal filed before the date specified in the notice of restitution. Otherwise, I'm going to be evicted before I even file my notice.
Well,
Perhaps. Oh, go ahead.
if that's the case, then is there any requirement that we have separate dates for all these things?
I
Maybe-
could live with requiring both the undertaking for costs and any supersedious undertaking both be filed within 5 days of the filing of the notice of appeal.
But if the in an FED, if the landlord had prevailed, if the landlord then seeks to enforce the judgment, they can enforce the judgment prior to that timeline.
Yes.
I almost
Yeah.
wonder. I almost wonder if there shouldn't be essentially a second timeline put in specifically for tenants to if they're seeking a stay of the enforcement of the judgment, that they need to file their notice and their costs and undertaking and supersede that they'd file all that in a 10-day window. If that's what they're seeking to do, it doesn't mean they can't appeal in the 30-day window later, but it just means they can't if they want to seek a stay of the enforcement, they have to do this different timeline for everything. How about that?
Well, is that what it currently is?
It's not the way the statutes are currently written, but that's for all practical purposes, that's what it would be. I mean, right now there's the 10-day, but it's not in that sense, but it's not spelled out quite explicitly like that. That if you're seeking a stay, these are the steps you have to take. So essentially, it would be maintaining or creating. We could put back into the 10-day time frame just for those individuals in FED cases who are seeking a stay of the enforcement of the judgment. I'm just spitballing here, but I'm trying to come up with something that works for where we're at.
And that gets us right back to what we had in the former law for small claims court cases where everything had to be done within 10 days, which you recognize was probably not reasonable.
But I also
now we're going to.
But I also recognize there's a difference between FED matters and timelines and small claims appeals, which is not the same rationale for rushing that. And again, we're talking about only in those instances where they wish to seek the stay of the enforcement of judgment, but I can't imagine an FED case where that was not the situation.
Mm-hmm.
I would point out that circuit courts hear FEDs, and tenants are subject to the same. Tenants and landlords are subject to the same 30-day appeal period. That is, the tenant has 30 days to appeal the judgment. But in most cases, the tenant files a notice of appeal much sooner than that because they are at risk of being evicted before the appeal is even started.
Well, right, Jim, but isn't that why we wanted to have a time frame for them to file? And if we could make the filing the same for both, we could, because then it's uniform. And if we make it uniform, that we just, we land on, is it going to be, 5 days? Is it going to be 7 days? Is it going to be 10 days? But it's within the date of filing. It has to be within 10 days of something. Or it has to be at the same time as filing the notice of appeal. But it would seem to me like it has to be one of those dates rather than say, that you file it that you have to file it by the time you file your notice of appeal, which would be 30 days later, which then gets into the problem that Anna was talking about with having somebody seek a supersedious a stay, and now we're 30 days post judgment, and they're on the steps of the house trying to lock them out.
What I'm saying is that's the situation in circuit court, and it's been that way forever, and it seems to work.
It
And
doesn't
I mean,
work in landlord tenant, Jim. That's the
it
whole idea.
works. It works because tenants realize that unless they file their notice of appeal within a few days of the entry of judgment, they're going to be evicted uh, before anything, before their appeal goes anywhere. So in fact, even though they have 30 days, in fact, they file within a matter of few days, and they file their undertaking for costs and their supersedeas undertaking uh, either at the same time or within a few days after that.
Well, actually, what Anna was saying is that sometimes that would not be the case. And what would happen is they would have to go through the expense of the writ of execution, going to court, to the sheriff, scheduling a lockout date. All of those things can happen. And you could be day 29 before the notice of appeal gets filed. And then the tenant files a motion for a supersedious for a stay. And that's what we're trying to actually have not be a problem for tenant and landlord every single time. That was the whole point of looking at this with the realities of how these cases are moving forward and how not to make them double up on each other and cross back on each other. Otherwise, we didn't have to change a thing.
I'm looking at 2460 and I'm trying to find the section that has the 30-day notice of appeal deadline, and I'm failing. Doesn't seem to say it in section 24 governing civil actions, so I'm trying to figure out where it is, and I'm sure I'm just not seeing it.
It's in section 8.
It's all the way up in 8. Okay.
Yeah, because there's like the generally applicable provisions and then there's the
Gotcha.
specific ones.
Okay.
And if anyone's curious, that is now 55-160. Just so people are aware, I did drop in the chat and I've been kind of editing it, some potential language to this subsection. And again, it doesn't need to be sub paragraphs of one subsection. It can be renumbered, 2, 3, 4 or something, but just based on what we're talking about.
Okay.
Yeah. That makes sense. All right. So currently, it looks like we were proposing within 5 days after filing the notice of appeal. And then for enforcement of a money judgment that you would file the supersedious undertaking promising to pay the judgment. And we had suggested the same dates of within 5 days after filing a notice of appeal. And real property. I'm just not clear why it would be a different time limit. And wouldn't it make sense to make it uniform so that you didn't have to worry about it? So it would be within 10 days after entry of judgment. Or within 5 days after filing of a notice of appeal, whichever is sooner.
Well, that's again, if you're talking about it as that would apply to every type of case, then it will continue to have the chilling effect, like in small claims cases that it currently has, because of how short the timelines are and people able to, especially pro se people, able to accomplish that and put it together in that fashion. And that was the small. I surely acknowledge that my desire to have it go from 10 to 30 was I was thinking with my brain in the small claims arena. And the FED arena presents a different issues and problems. And I think that there is a good argument that there should be a distinction betwixt FEDs and the other types of appeals. So I think having two different timelines,
Isn't necessarily
having a
bad.
different timeline for FEDs makes sense to me.
Mm-hmm. Well, and isn't it just as long as we're clear about the two different types that we are, that's what you want? I mean, if somebody's looking at this, they're not going to look at a statute globally and say, this applies to me, when it's truly, if they know that what it is a FED case and it's the recovery of the real property that is being sought, then you have to look at that rule to say, how long do I have to do this, and what do I have to do to preserve my rights under it?
I agree, and I also think it's incumbent upon the courts to give them that information at the conclusion of the case,
Mm-hmm.
before you let them leave the courtroom.
Right.
I certainly endeavor to do that, but I can't. If you're going to ask me if that's done universally, I won't be able to tell you. Ms. McCormick would be better versed than I and how other courts handle those things.
Right. Okay. So is there a place that we can set the time frame? So we have proposed language that is 2A and then 2B in order to stay enforcement of a money judgment. It would be within, if we added the time limit of within 10 days after entry of the judgment, or within 5 days after filing the notice of appeal, since the notice of appeal can be filed with 30 days, so it would be 35 days after filing the note after the judgment. And in order to stay enforcement of a judgment for the recovery of real property, then the supersedious undertaking would have to be filed. Looking at 6 now. No, that doesn't answer it just yet. Let me go back to the draft.
Well, I think if we're talking about filing the notice of appeal,
that also says within 5 days after filing the notice of appeal. And in that case, it just really depends on when the tenant was going to appeal. And if the tenant wanted to appeal quickly so they wouldn't be out of their property, isn't that their option? Like, to quickly get in and file their notice of appeal? I mean, if you really wanted to stay on your property, you wouldn't wait 30 days to file a notice of appeal because you might be out on the street by that time. Right?
What I've been saying.
So
I think the real world imposes a time limit that need not be in the statute.
Well, I think we do want it in the statute, but I don't think that there's a problem with having it be within 5 days after filing the notice of appeal, if in reality we are protecting the tenant, giving them that right to do that, and also we're giving them the time that they believe they need, which may or may not be the landlord's preference. The landlord probably doesn't want to see undertaking to stay enforcement on day 35, but the tenant could do that if the tenant wanted to risk the uncertainty of not knowing whether they'll be out before that date or not. I mean, they would be gambling.
They may have already been removed by that point if they wait that long.
Perhaps, but they know that. I mean, if they know that, then they know that they need to get that notice of appeal in to put the brakes on the execution of the judgment. Which protects kind of them and the landlord. So are we looking for a fix that we've already fixed with this proposed language?
What I'm hearing is that, and correct me if I'm wrong, but that people actually just think that it makes sense to also use Jessica's language in 2B and C and just pick the one that says within 5 days after filing a notice of appeal.
Yeah, that's what I think makes sense looking at Jessica's language and what we just talked about. Is everyone okay with that?
Yes, and I thought I heard someone suggest that perhaps the statute could actually say that a judgment remains enforceable until a notice of appeal and a supersedious undertaking is filed. I think that puts everybody on notice that, yeah, you have 30 days on the outside, but you may want to file sooner.
Mm-hmm. Mm-hmm.
Yeah, I have a note on that, but I ran out of characters. You can only have 1,000 characters. I didn't know
that. So Jessica, if you can include that language, I think we could be okay with that.
Okay.
I think that then gives people information that is helpful for them informing their decision.
Did we want to add something about a form being created, like a model form?
Yeah, if we can use the same language that was used before I don't know what that language was, but was there language that kind of suggested or asked the Department of Justice? I don't know how directive the legislature can be with telling people to create forms.
Oh, we can. In 2460, we had the state court administrator create model notice of appeal forms, so I could use something similar here.
That sounds good.
I just think in the FED that one of these forms for the supersedious undertaking would be a
I'm
good
not
form.
sure that the circuit court provides supersedious undertaking forms. An FED appellant is appealing to the Court of Appeals. I know there's a notice of appeal form, but I'm not sure that they have a supersedious undertaking form.
Okay.
I think that's right. I think that would be a new obligation that OJD doesn't currently have in the parallel structure and doesn't currently do, but we can definitely, if that's the direction that this group is going, we'll take it back and run it up the flagpole and make sure we don't have any issues with that.
Okay. Yeah, I think that would be a good thing. I think it would be a good form, and whether it comes out of OJD or DOJ, but probably OJD, just especially for self-represented litigants, most of these cases involving self-represented litigants, at least on the tenant side, and often on the often both parties in a small claims type case.
If we have one more minute too, one other thing that we had questions about where this group was going was subsection 7 of the draft that had to do with the appeal to the circuit court of the justice court's determination on the undertaking. And I just didn't know if we had landed on this wording or if this was still a discussion point. And I think maybe we had some feedback on there. Katie might have more information on where we want to, pieces we wanted to talk about. If this is the direction that we're going, are we going? Because I remember last meeting we had some back and forth about whether or not there would be circuit.
I mean, I'm still willing to consider, but I have run this up the flagpole with a couple of presiding judges in various counties, larger and smaller. And there is a decided disinterest by the circuit courts in having an interlocutory appeal of the undertaking in cases that are headed to the circuit court anyway. They were just like, that would just, for some of these counties, that would create a whole subset of hearings that they don't have bandwidth for, and they're not things that they would probably get to in the way that we might have envisioned it. And in the smaller counties, they said, we get these cases in as quickly as we can, and if we're being asked to do 2 hearings rather than 1, that's not going to go over very well. So that's just the 2 cents I received from the presiding judges I checked with in 2 different neighboring counties, judicial districts. So I don't think that it is probably something that we have to include. And I think if we're trying to just make this a cleanup motion, that's adding a lot of judicial time and resource in an area that there isn't a lot of interest on the part of the receiving courts.
I think the main, to chime back in on that, the main concern, I think one of the main concerns articulated in wanting a standard of review was, a judge ordering back rent and attorney fees and things like that. And the language we've added that has a clear prohibition against that would seem to address that concern, such that some sort of interlocutory appeal of that type of ruling perhaps could be circumscribed by the addition of that guidance language.
That's a really good point, Anna. And I think that was something that I forget if it was Judge Cross or Judge Kidd had asked for, was just tell us, give us, just lay it out for us what we shouldn't be considering or what we can consider. And that makes it a lot easier for people not to go over their skis and not to cause that kind of inadequate, or not inadequate, but just unequal treatment of what that bond needs to look like. So, with all of that conversation, are we in a place where we can make a recommendation to the task force next week?
Well, if I could address one other issue in just above subsection 7 is subpart 4 6, and it addresses the topic of the once the appeal is over, having either the circuit court or the justice court direct distribution of any rent that a tenant may have deposited with the court. My only concern is the very last phrase, quote, which is to compensate the landlord for the fair market value of the property independently of the appeal. I don't think that's necessary because the subsection 6 has already made clear that that's what the purpose of the undertaking is.
Okay. Okay, so it would just be the purpose of the undertaking, period?
I think so, yes.
Are we all okay with that?
I think so, because Jim, doesn't the fair market rental value language come in that the other subsection above about with the deposit to the court each month?
Yes. Three
Yeah.
and three.
Yeah, because we would just be redundant in a repetitive fashion if we put it in again.
Okay. So can we take that part out, Jessica?
Sorry, I was giving a thumbs up, but yes.
Okay. All right.
One other thing,
Oh,
and this is a
alright.
really minor point, but back to the undertaking for costs. The statute currently says that the undertaking for costs shall be in the amount that may be awarded against the appellant on appeal. And I'm thinking from the appellant's point of view, from the typically pro se defendant's point of view, they have no idea what that is. That means they have to find out what costs can be awarded on appeal and how much those are. By contrast, in circuit court, I think the undertaking is set in a fixed amount of $500, although the court can modify that. It's a presumptive amount. I think, but I'm not sure, that the only cost recoverable by the respondent on appeal is respondent's filing fee. So I was thinking of saying that the amount of the undertaking for costs should be the amount of the respondent's circuit court first appearance fee, or that amount would be presumptively correct, leaving it open to the plaintiff to perhaps argue that there are other recoverable costs. So we can't say a fixed amount because the circuit court filing fee changes from time to time. But I think I would like to have a little more direction as to what how much the undertaking for costs requires.
Which section are you talking about, Jim?
This would be in back in subsection 2. The current wording says undertaking must state that the appellant will pay all costs and disbursements that may be awarded against the appellant on appeal. And I'm saying most appellants are going to have no idea what that is. So why not just say it's the respondent's first appearance fee in circuit court? Or at least say that amount is the presumptively correct amount.
I don't think we need to go to that minutia. I mean,
Yeah.
that seems. I'm not unhappy with the way it reads now.
Okay.
It just says that may be awarded because the trial court, the justice court doesn't know what the circuit court will necessarily do with that. It's just
Right.
you see, so you don't want to provide false, what could be misleading information
Right.
to an appellant.
So then how is the appellant supposed to figure it out?
Well, they don't
Just
figure
a
it out.
Supposed to figure out the
recitation.
supersedious and the timeline and thing like that, which is much more confusing than this, Jim. I don't understand why you get concerned about it in one area but not the other.
No, what I'm saying is, like in circuit court, the undertaking cost is in the amount of $500. That's what the statute says. Then it can read it. Okay, I know I have to file my undertaking for cost amount of $500. Here it says the cost that may be awarded against me on appeal. How do I know? I'm just a pro se tenant, a pro se defendant. They have no way of knowing what costs may be awarded against them.
I think that they have just as much of an easy way to find out that as they do to find out that if they want to get a stay of enforcement of judgment, what they have to do, which we're not going to tell them in the statute.
Yes, we have told them the amount of for a supersedeas undertaking for a money judgment, it's the amount of the judgment. For a supersedeas undertaking for the recovery of real property, it's the monthly rent.
Okay, well, here's the thing, Jim. I don't think you could tell somebody necessarily what costs and disbursements might be awarded against them at trial, because if they go to trial, they may decide they want to be represented by an attorney. The other side might say, well, if you're going to be represented by an attorney, we're going to be represented by an attorney. And oh, this particular statute that you're appealing a judgment from allows for attorney fees. And so the court could award attorney fees as costs on appeal. And the bond is not going to do that.
No. Attorney fees are not costs.
But
costs have a very specific meaning. It used to be the filing fee and the $10 prevailing party fee. But attorney fees are not costs.
Okay, what about awarding costs for subpoenas?
That's why I'm saying in some instances, additional costs may be recoverable, but the respondent is not going to, neither the appellant nor the, so you're going to ask the appellant to figure out, that the adverse party is going to issue subpoenas, and then they have to figure out how much those costs?
No, what they're doing is they're filing an undertaking, say, I understand that I may be charged with paying costs. I get that. I don't know what those costs will be, but that's, if I need to know, I better ask somebody, but we can't promise them that it's not going to be more than X dollars. We can't do that.
Well, in circuit court, it's set at $500. Well, okay, let's not, can we just say for $300 that the undertaking for costs has to be an amount of $300 or $400 or $200? Same way it is in circuit court, a fixed amount.
I think that's part of what it would, the concern being expressed is that many of these folks would read that then as what that's the maximum, or that's like the most they're going to get hit with, when in fact that may not be correct.
And so that's why I'm saying, let's take out the costs on appeal and just say that the undertaking for costs must be in the amount of $300.
And then with the circuit court orders, $800. Are you saying the circuit court would be precluded from doing so?
No. On appeal from a circuit court, the statute says that the appellant has to file an undertaking in the amount of $500. That does not limit the Court of Appeals in awarding costs in some other amount. It might be more, might be less. Now, we know that the measure is kind of an estimate that in most cases, the respondent will incur costs on appeal of about $500. But appellants don't need to know that. They just need to know that their obligation is to file an undertaking for costs the amount of $500, circuit court. And here we can do $200, $300, $400, whatever amount we settle on. Let's just make it much easier for people, because the way it is now, we're making it harder for appellants from justice court than it is appellants from circuit court.
If an undertaking is filed out of justice court, that's not money in the bank. That's right?
No, it is. And that's what I was thinking at first. But if you look at 1A of section 25, it says it's a written promise.
Right.
Supported by a bond, surety, or deposit of money.
Okay. And what are they currently paying on these kinds of appeals?
To my knowledge, the only recoverable costs are the respondent's filing fee.
Well, if we want to say they have to pay a written promise signed to that is supported by a bond or a deposit of money with the justice court in the amount of the respondent's filing fee, whatever that is, period. But that's not all costs and disbursements that may be awarded against them on appeal. That's just a random number.
Right.
Oh,
That's
so
why
you're,
I'm saying you, that's
so
why I'm saying if you'd rather go with a fixed amount of $200, $300, whatever, I would be fine with that too.
okay, but then it shouldn't say that it's all costs and disbursements that may be awarded against them on appeal, because that's not
No.
what we're talking about. We're just talking about an undertaking means that you're going to pay the other side's filing fees.
Yeah, I think we should take out the reference to costs that may be awarded on appeal and just say that the undertaking must be in the amount of $300 or whatever.
Well, why wouldn't we say the appearance fee?
Oh, we can. That's fine too.
Because then you don't have a number that goes up or down or goes up and up.
There's also a trial fee.
Yeah. And how
Didn't we remove the trial fee? In 2460, didn't the trial fee go away?
Oh, did
Jim,
we?
am I correct?
That was my recollection.
I'm so sorry to bother you, but I know that Jessica and probably Katie and I need to go at 2:30 for judiciary, and I know Anna asked us to not go much over an hour because she has
Yes.
trial tomorrow. So
Right.
I just want to flag everyone's time.
Okay, thank you. So why don't we look and see what the current, if somebody could tell us at some point before next week what the undertaking, what the costs are that the person is required to pay. And then we can work the language so that it doesn't say anything that may be awarded on appeal, but it does say a specific amount that they have to promise to pay or deposit on appeal. And it would either be filing fees or trial fee or whatever it is, but let's just find that number. And I don't think we have to look at it more carefully than that right this minute. And then I think we need to let everybody go because I also have to get on the freeway and be in Portland in an hour. So
I don't think you can do that without speeding. I gotta caution you.
I know. I'm always late for meetings, let me tell you, unless they happen in my house.
I might wind up seeing you as a defendant in my court, I'll tell you.
Yeah, I don't want that to happen, I promise. All right. Well, thank you all for this very robust discussion. I really appreciate it. And hopefully we have enough information we can go forward. And if we can't, we can't. It's not the end of the world if we are really, really close and not quite there, because we do have more time for meetings. But I really appreciate the hard work that was done today by everybody.
Thank you.
With that, we can adjourn and hopefully we'll see most of you next week.
Thanks.
Thank you.